Hi, everyone. I'm Behnam Dayanim. I'm partner and global chair of the privacy and cybersecurity practice at the law firm of Paul Hastings. I'm based in Washington, D.C., although I haven't seen Washington, D.C. for many, many months. I'm doing this broadcast or video webinar from my home. I'm glad to be here with all of you. I'm going to talk today about how to manage privacy in cyber in a pandemic, lessons learned for 2021 and beyond. So what are we going to talk about? Well, COVID really has both accelerated certain trends and also upended certain pre-existing assumptions that people had about data privacy and cybersecurity prior to the pandemic. It's accelerated the transition to remote work. It's of course increased reliance on remote resources. And at the same time, it's really changed expectations about what types of data employers might expect from their employees. And I think both of these trends are likely to last much longer than simply the length of the pandemic, which itself has lasted longer than I think many of us would have anticipated and certainly would have hoped. And both do have very significant implications for privacy and cybersecurity. So let's dive into them. So firstly, in terms of upending expectations, as many businesses start to move into the office reopening phase, one of the real questions that they face is the types of information that they're collecting. And I think it's important for those of us who serve in privacy or in cybersecurity roles or as legal counsel to really challenge the extent of information that is truly needed for office reopenings. For example, we know that many businesses are conducting temperature checks of employees when they enter the building and turning folks away if they show a fever or other signs of illness. Is there really a need to record that? Or is it simply enough to know that you have that process in place, and so that anybody who's been admitted to the building has satisfied those criteria without having to record that Jane Doe or John Smith had their temperature checked, the temperature was X, or even Jane Doe was turned away because she failed the temperature check. It's not really, the question is it really necessary to have that information? I would posit in most cases it is not, right? And if there is an insistence that any particular item of information is needed, then it really should be questioned and challenged and documented as to why it is that information was needed. And once you've gotten past that stage and have decided that you actually do need the particular data element, then of course there's a question about how to collect and store it and to ensure that it is protected. And also it's important, I'll talk more about that in a moment, it's also important to understand state and local mandates on reporting positive test results and contact tracing. Those will vary from state to state and from locality to locality. In many cases, there will be obligations incumbent upon the employer if they become aware of a positive test result to notify the authorities, which runs counter in many respects to a traditional privacy standpoint in terms of not sharing employee information. Here, those laws would trump any ordinary default position and would in fact require disclosure. Now, what's interesting, I thought some interesting data points might be of interest here in this regard. An IAPP EY report that was done just within the past 6 weeks or so looked at data collection efforts by employers. And as you see here on the slide, indicated that many employers, an overwhelming majority, 76%, have asked employees to notify them if they are diagnosed with COVID. A little over half have asked employees about their personal travel. A little over a third have asked about household members' COVID status, and a little under a quarter had taken temperatures of employees along the lines that I was just describing a moment ago. All of these things are really quite novel, quite remarkable when you think about it, not the kinds of questions that one would ordinarily have expected employers to be asking of their employees. And I would posit that we will see in the near future an additional question here, additional bullet point if this survey is done a few months from now regarding organizations that have asked employees to notify them if they've been vaccinated. That'll be the next step. And the question that companies will have to grapple with is to what extent they want to know that information. In addition, 3 in 10 organizations have been asked to share anonymized COVID data with a third party, whether it's a government research organization or an NGO. 20% have shared the names of staff who have been diagnosed, either with other employees or with government officials, and I'm going to talk a little bit more about that as well. 15% have conducted a DPIA, a data privacy impact assessment, focused on COVID collection. That's a good thing to do. I'm sure most of you watching this know that when you have a robust privacy compliance program, one element of that is to conduct a privacy impact assessment before embarking upon a new process or adopting a new system or technology that will involve the collection of data. And about half have adopted a new technology to enable work from home. And interestingly, and in some ways, certainly understandably, not surprisingly, but also of some concern, the majority of those have bypassed or expedited their privacy or security review. There's nothing necessarily wrong with expediting privacy or security review of new technologies, but bypassing it certainly does raise potential vulnerabilities that we'll talk about. Okay, so I alluded to temperature checks earlier. As I mentioned, the kinds of questions that one should ask when thinking about something like a temperature check is, do you really need to record the responses? Who collects those responses, the building itself or the employer? And as I mentioned, is it necessary to keep it at all? If you're asking for testing information, when do you require testing of your employees? That's not an obvious question. There's not an obvious answer to that question, and the answer will depend in many respects on the company's own particular circumstances and the characteristics of its workforce. What do you do with the results? As I mentioned, positive results in many places will require reporting to governmental authorities. Negative results will not, and so the question that becomes, how long do you retain those negative results? There's no one size fits all here, but it's the kind of question that you have to approach in an intentional fashion. And how do you communicate a positive result to the workforce? So for example, you have an employee, Jane Doe, who tested positive. Do you send an email to the entire workforce at that location saying that Jane Doe tested positive? That would not be the right answer. That's almost never, in my experience, the right level of disclosure. But you might say something like, an employee who was last in the office on December 23rd tested positive. He or she worked on the 10th floor. And you might send that to people in that office and not in other offices, so that you're providing the information necessary for people to make a determination as to whether or not they themselves might have come into contact with that person or need to take some step to take care of themselves, whether it's to monitor their own symptoms or obtain a test result. Those are the kinds of questions that are important to think about now before we have wide-scale reopening, because even post-vaccination, there will be some number of people, and probably quite a large number of people in the shorter term, who have not been vaccinated and who might therefore be susceptible to the virus. And the vaccination itself is not 100%. So this kind of question will be something that I think is going to be with us for quite some time, and understanding and having in place a process to deal with it will be really important. And then, as I mentioned, whom to notify. The public health agencies will typically require notification of positive test results. And so each employer location should really know who those agencies are and have the contact information necessary. Another very important question is secure disposal. If you are storing testing data, for example, in addition to determining how long you want to store that information, you really should have a plan in place for securely disposing of it. That's not unique to test information. That's true of any personal data, but this is just another example of the importance of that element to a data protection program. Okay, now this is quite important and quite often not understood, and that is the interaction of COVID testing results, testing data, with HIPAA. HIPAA, of course, is the federal law that governs the protection, the privacy and security of protected health information. It imposes quite rigorous requirements, and it does not apply here. And the reason it does not apply is that HIPAA covers protected health information. And protected health information is health information, but not all health information. It's health information that's been created, collected, transmitted, or maintained in connection with the provision of healthcare, the payment for healthcare, or use in healthcare operations. When you have an employee take a COVID test or have a temperature check for that matter, that is not in connection with the provision of healthcare. That's for employee safety place of employment safety. It's for employer-related business operations reasons, not for healthcare operations. And so therefore, as a general matter, employee testing won't fall within the scope of HIPAA. So that has implications that are both, that go in both directions. In the first instance, it means that when you're engaging vendors to provide tests, employee tests, or conduct employee tests, or to collect temperature checks or other things in connection with this kind of activity, you have to review those vendor agreements carefully, because often the vendor who might be administering the test is a vendor that also engages in HIPAA-related activities. And so to address, for example, security requirements or privacy requirements, the agreement might just simply have some boilerplate that says, well, we will comply with applicable HIPAA requirements. But that's meaningless in this context, because this activity largely isn't subject to HIPAA, so there will be no applicable HIPAA requirements. And so you have no protection as the client in dealing with that vendor. So you have to modify that provision to say either that they'll comply with HIPAA requirements notwithstanding or irrespective of whether HIPAA applies, or a better option is to actually build in specific requirements for privacy and security. The flip side of this is that you also have less protection in the event of a security incident or a data breach, because if the information is not PHI, that means it's not subject to HIPAA's breach rules. So if there is a disclosure of that information, it's not treated as a HIPAA breach, which actually can be good or bad. In many cases, it can be good because it means you don't have to assume that notice is required under HIPAA to DHS, to HHS, excuse me, to Health and Human Services, because it's not a HIPAA breach. And so it's important to understand whether the data in fact is covered by HIPAA. And if it's not, it's important to spell out what steps will be taken if there is a breach. And that's something that should be addressed both ahead of time in your vendor agreement and also internally through your internal policies and procedures. We had a client not too long ago that actually experienced this, where there was a breach involving COVID testing information, and a lengthy dialogue ensued between the client and the vendor over whether it was HIPAA reportable, because they did not undertake that exercise or analysis at the time they entered into the agreement. Ultimately, they concluded correctly that it was not a HIPAA event. The vendor ultimately agreed, and as a result, the HIPAA security breach provisions did not come into play. But had they simply assumed it was subject to HIPAA, they would have gone through that whole process without me. So that's an important thing to keep in mind. Okay, what about accelerated trends? Well, the obvious one is, of course, that the increase in remote work has not surprisingly led to increased cyber attack. And I have here some examples thrown up on the slide that come from Verizon Business and from Tessian. Increased distraction has caused increased success in cyber attacks, in particular phishing scams. When I was just setting up for this presentation, I was distracted in setting up because I had one of my children calling for me, and so a picture fell off the wall, right? That's the kind of thing that when you're working at the office doesn't happen, and at home it does, and it can cause employees to pay less careful attention to what they're doing, and that is in fact, I think, one of the drivers of the increase in successful phishing scams that we've seen. Web application breaches, heightened ransomware attacks, the whole host of types of increase in remote attacks that are increased in cyber attacks that are resulting from increased remote work. And really what that does is place a premium on continuing to do what people already should have been doing. But also from a cyber security professional perspective, it really increases the importance of keeping abreast of best practices, because best practices are evolving more rapidly than they did before. It was already a dynamic phenomenon to begin with, and now that's increasing. What was best practices 6 months ago is not best practices today. And so it's important for the cybersecurity professional to know that and to keep up to date so that they can continue to maintain a reasonable approach towards cybersecurity. And reasonableness is important because many of there are more and more federal and state regulatory requirements that adopt a reasonableness standard, saying you have a reasonable WISP. WISP is, of course, Written Information Security Program. A reasonable WISP in place, and reasonableness often turns, in part anyway, on industry best practices and on the foreseeability of risks. Now, of course, in the HIPAA context, there are specific and very granular cybersecurity requirements. That's also true, for example, in the New York DFS cybersecurity regulation, which applies to financial services companies that are licensed by the New York Department of Financial Services, but that's not generally the case. When you're talking about the venerable Massachusetts data security law that has been in place for many years, for example, or the more recent CCPA, California Consumer Privacy Act, and its successor, the California Privacy Rights Act, which will take effect in 2023, they talk more in terms of reasonableness. And certainly the Federal Trade Commission, in looking at data security, looks at reasonableness and explicitly looks at it in the context of industry best practices, among other things. So what does this mean? What are the implications here? Well, as I mentioned, number one is it really requires keeping abreast of what the industry is doing, knowing what your competitors and peer companies are doing. It also really requires increased communication between IT operations, which is continuing to roll out newer and better remote working solutions, and info security. As each business process changes, InfoSec needs to be in the loop. They need to be in the loop early so that they can understand and facilitate the implementation of those solutions. InfoSec is never successful if it is always saying no or always slowing things down. It really needs to help facilitate, but the way you can help facilitate responsibly is by being involved early in the process. In addition, I would suspect that almost every company's data maps may be out of date by now if they predate COVID, because where data is being kept and how it's being handled has changed. And so updating data mapping is important, because without good data mapping, it's hard to know whether you have vulnerabilities that you haven't identified. Increasing training, especially around phishing with your user base, continually reminding them of the importance of being vigilant, using simulated phishing, those kinds of things, which already are things that should have been in place, and I'm sure many companies already were in place, need to be reinforced and made more frequent. Hence my comment that these are accelerating trends. In addition, hardening resilience. I would hazard that most business continuity or disaster recovery plans were not predicated on indeterminate remote work. And that's really what we are living with today. And so making sure that those plans that were designed for a very different environment are still useful and sufficient today is really important. And then lastly, updating and revisiting your incident response procedures to make sure that they make sense, that they still fit with what you're trying to do in today's environment is important, because in a distributed workforce where no one is in the same location and where there are multiple responsible parties, an incident response program that may have made sense a year ago may not make sense today. And so that's really important to understand. Speaking of data breaches, there's also another development that's not related to COVID, but is coincident with it in timing that I think is worth talking about. And it arises out of a court decision this past summer in Virginia in connection with the Capital One breach, where the court ordered Capital One to disclose its forensic report. And that was shocking to many, because the forensic report has been regarded often as privileged, protected under the attorney work product privilege. And in fact, that's the position that Cap One took in that case. The court said no, it was not, and required that it be disclosed to plaintiffs in the class action that has been filed, or that was filed in connection with the breach. So what are the lessons that one learns from this? Number one, it's not sufficient to have counsel involved in the forensic process. Instead, you should retain the vendor through counsel. So that it's counsel that is retained and is responsible for the vendor. Now, many companies have pre-existing relationships with vendors. They might have a flat fee kind of arrangement, an ongoing counseling arrangement, something along those lines. And that's the vendor that they want to use for the forensic in the report in the case of an incident. That's totally fine. But what you need to do in that case is enter into a special statement of work or project schedule for this project. And that particular SOW will be between counsel and the vendor, even if it's governed by the terms of the master services agreement, and make very clear that that work is going to be conducted under the protection of privilege. That's number one, but that's not enough. Number two, counsel really needs to be involved in a meaningful way in directing and shaping the investigation. It can't simply be you'd CC'd them on your emails to the vendor. And courts really, at least if they follow the Cap One precedent, will be looking more closely at that kind of thing and ensuring that, in fact, counsel played a real role. number three, well, I'm going to skip number three on the slide. I'll come back to that. I'll go to number four, and then I'll come back to three. So number four, the report really has to reflect legal involvement. And by that, what I mean is, what the court in Cap 1 said was, among other things, this report is the same report that would have been written if counsel had never been involved. And so there's really no impact of counsel's involvement other than to try to claim privilege. And that's not what attorney work product is intended to do. Attorney work product is work product directed by counsel, prepared in anticipation of litigation or investigation. And so it needs to reflect, and this is my editorial addition to what the court said, it needs to reflect that legal direction or input. There's something about the report should on its face, should reflect the fact that counsel was involved in directing and shaping it. And so that's I think very often overlooked and very important. It's not a new requirement. It's not something the federal court in the Cap 1 case created. It's always been the standard. It just hasn't always been applied so rigorously. And I think moving into a post Cap 1 environment, it very well could be. And so that's something important to keep in mind. And then lastly, going up to my third bullet, you really should decide what you really need to be written down. There's a reflexive tendency to want to have everything in writing. And vendors like to do it because they could show all the beautiful work they did and the thoroughness and comprehensiveness of their report. And the clients often like it because then they have something they can refer to. But the problem is that you create a record that you may not need. There may be a whole host of findings in the forensic report that are unrelated to the incident or that are immaterial, but that nonetheless show up as findings. And if you then don't address each one and instead leave some open, which might be a very reasonable decision, then in the future, if there's a litigation in connection, let's say with another incident, and this report gets disclosed, you're going to have a lot of explaining to do, and it's going to create unnecessary suspicion about the adequacy of your information security efforts. And so really thinking hard on what you need to be in writing is important. And then even if you decide, yes, we do need a written report, and you decide what it should have in it, that should be conveyed orally in a conference with the vendor and the client before anything gets written down, so that you can make sure that everybody's on the same page as to what the report will contain. And then when the report is drafted, it should be sent in draft form to counsel first to make sure that, again, it reflects the expectations of the parties before it is finalized. So it requires a very deliberative process. It's certainly doable. There's nothing about the Cap 1 decision that says forensics reports can never be privileged, but it requires thought. Okay. Ransomware. Ransomware is, as everyone knows, an increasingly common type of attack. I just want to mention one thing briefly here. Again, this is not a COVID-related phenomenon, but it's coincident with it in terms of timing. In October of this past year, OFAC inserted a ransomware advisory. Now, the advisory basically just restated existing law, which is that if you do business with, which includes making a payment to, a sanctioned party, a person who is listed on OFAC's list of bad people, right, then you're violating OFAC sanctions. And it's a strict liability standard, meaning you don't have to know the person is sanctioned. If you simply make the payment or engage in the transaction with that person, then you have potential liability. And that's really all OFAC's advisory says, and that's always true. And then OFAC goes on to say, and if you seek a license, meaning you discover that the ransomware attacker is a sanctioned party and you want to make the payment anyway, and so you come to OFAC for a license to do so, which is what you would need, there's going to be a presumption of denial. We're going to presumptively, we're telling you, you're going to have a really high burden to show before we're going to allow that payment to be made, meaning we're probably going to deny the request. So what does that do? It puts companies that are victims of ransomware attacks in a very hard position, because number one, you almost never know who the attacker is. So you don't know whether they're a sanctioned party or if they're in a sanctioned country like Iran or Cuba or Syria. You don't know anything about them. That's the whole point. They require payment through cryptocurrencies, and it's to addresses that you can't really track. So you don't know. And so then you run the risk of, okay, do we make the payment and risk later to finding out or having it be discovered that the party was a sanctioned party? Or do you not make the payment for fear of violating the sanctions? OFAC doesn't give you any help in that regard. And that's not surprising. The government generally has not been supportive of making ransomware payments, but it's something companies need to keep in mind and decide how they're going to address ahead of time. Obviously, the the best position to be in is you don't need the access to the data that's been ransomed because, or that's been interdicted, because you have backups, but you need to have a policy in place for how you're going to deal with ransomware attacks proactively. Okay, last thing, because I'm running short on time. Again, not COVID related, but coincident in timing. Hong Kong. The reason I mention Hong Kong is it's been on the minds of many of my clients. For many years, many of them with Asia operations relied on Hong Kong as a data center location for a number of reasons, including convenience, availability of bandwidth, trans-Pacific connections. And they were comfortable doing so because Hong Kong was separately administered from China. As I'm sure all of you know from the news, that's really no longer the case. China has extended its national security authority over Hong Kong, meaning that Hong Kong locations really are now subject to Chinese surveillance and Chinese process, just as if they were in mainland China. And that really creates a significant security issue for companies to consider. Many of them have considered have actually started already relocating data center assets out of Hong Kong to other locations in Asia. Most commonly Tokyo, and that's I'm not an IT person, but my understanding is Tokyo also is blessed with a large number of direct trans-Pacific connections, whereas other locations such as Singapore or Seoul often go through Hong Kong, and so you still have a similar problem. But figuring that out is important, and it's also important to the extent that you don't relocate, or even if you're not able to because you're going to have Hong Kong presence of some kind. And that is developing, or if you have already, revisiting your internal escalation procedure on what your folks on the ground should do if they're served with a government order to turn over data, turn over records, how to state an objection, how not to. It's not necessary, nor is it appropriate to require you to put your employees to put themselves at risk of arrest. But there are ways they can nonetheless create a record that they objected to a particular search or seizure, whether they can follow investigators as they go through an office and collect materials, keep a record of what was taken, whom they should alert internally when they're approached. There should be an immediate escalation procedure so that your person on the ground in Hong Kong knows who to call or who to email when they're approached by the government, so that the company can take appropriate steps. Those kinds of written procedures, which many companies have multi-jurisdictionally, should be really reviewed in the Hong Kong context with an eye toward Chinese and Hong Kong specific considerations. Okay, so what are our actions? What's our recap from what I talked about? So what should people be doing today? Review your reopening protocols. Hopefully we all will be reopening soon. Understand what kind of data you're collecting, how you protect it. Ask, question, challenge, do we need these data? Do we really need to collect this information? Review your ransomware response procedure so that you know how you're going to address payment demands, and have thought carefully about the OFAC issue that was identified in the advisory. OFAC is making clear this is important to it, and so it needs to be important to you in terms of at least how you think about it. In the coming weeks, really already, in many cases, companies are doing this and should be, consider ways to minimize your data exposure to Hong Kong. And every day, really review your information security protocols and programs. It's more important than ever to keep up to speed with what your peer companies are doing, and to ensure that your security precautions have adapted to the changed circumstances in which we live and work today, and which will almost certainly continue in some measure even post-pandemic. And that's it. Thank you very much.